Hello everyone, this is Urvashi Chauhan and you are watching Courts Today by LiveLaw. We bring to you the latest and in-depth legal coverage, coming to you with a brief of what all happened in the Indian courts today. Starting with Day 2 of the hearing on legal recognition for same-sex marriage in India by the Constitution Bench of the Supreme Court. Yesterday, the court had clarified that for now it would be limiting itself to the ambit of Special Marriage Act and not touch upon personal laws of respective religions. The bench today faced an issue regarding the age of the partners under the Special Marriage Act. So we know that under the Special Marriage Act, as per Section 4, the legal age to marry is 18 years for a female and 21 years for a male. The question was, how would this be decided for a same-sex marriage when we are above the very notion of a man and a woman? On this point, the petitioners seemed to be inclined to consider the age according to the gender they manifest. But the bench did not seem pleased and said that doing so goes ultimately back to the social stereotype. Further, the discussion continued on degrees of prohibited relationship under the said act. In response to centre's submission that those seeking marriage equality for same sexual groups merely represented urban elitist views, the petitioners cited examples of transgender people who, disowned by their families, had to beg on streets and drop out of schools, etc., and thus this could not be termed as an elitist concern. Senior advocate Abhishek Manu Singhvi argued that those who seek marriage seek it for community and social validation of a relationship, for the sense of security and the greater financial support. He said marital status by itself was a source of dignity, fulfillment and self-respect. The bench will continue hearing the matter tomorrow. You can also watch the court proceedings live on our YouTube channel. In another important update, the Supreme Court of India today set aside an order of the Bombay High Court acquitting the former Delhi University professor and activist G.N. Saibaba as well as others over their alleged Maoist links and remanded the matter back to the High Court to be considered afresh by a different bench. To give a short background of the case, Saibaba and 5 others were sentenced to life by Sessions Court in Maharashtra in 2017 for offences under the Unlawful Activities Prevention Act UAPA for their alleged association with the Revolutionary Democratic Front, which was alleged to be an affiliate of outlawed Maoist organization. Saibaba, who is bound by wheelchair due to post-polio paralysis, had earlier filed an application seeking suspension of sentence on medical grounds. In 2019, the Bombay High Court had rejected his application. But in 2022, the Nagpur bench of Bombay High Court finally heard the application and discharged Saibaba and other accused of all charges. The court had held that trial to be null and void on the reason that valid sanction as required under Section 45 of the UAPA was not obtained. Following this, an SLP challenging the discharge order was filed in the Supreme Court, which was heard by the Supreme Court on a special Saturday evening, inviting a lot of criticism. Thereafter, the matter came up again for hearing yesterday. The counsel for Saibaba sought time for instruction on the question of remanding the case back to the High Court for fresh consideration. The case was again posted today and the bench headed by Justice M.R. Shah sent the matter back to the High Court, stating that the Bombay High Court could consider all questions arising in the matter, including that of sanction. The Supreme Court further stated that it would be open for the state to contend that once an accused is convicted after the conclusion of a trial, the validity of the sanction would become insignificant. The bench has also directed the Bombay High Court to dispose of the appeals at the earliest, preferably within a period of 4 months. And now coming to an update on the killing of Ahmed brothers in Uttar Pradesh. A magistrate court in the Prayagraj district today sent 3 accused in the Atique Ahmed and Ashraf killing to 4-day police custody. They will be presented before a court in Prayagraj again on April 23rd. As you already know, the Ahmed brothers were shot dead in a shocking incident on Saturday night at around 10 p.m. in police custody in front of the media while they were being taken for a medical examination. The UP government has set up a judicial commission to inquire into the matter, to be led by retired Allahabad High Court Judge Arvind Kumar Tripathi. Also, the National Human Rights Commission has taken cognizance of complaints concerning the Ahmed brothers' killings. The Commission has issued notices to the Director General of Police, Uttar Pradesh, and the Commissioner of Police, Prayagraj, calling for detailed reports covering all the aspects leading to death, copy of FIR, the post-mortem report, etc. within 4 weeks. Earlier this week, a PIL was filed in the Supreme Court seeking the constitution of an independent expert committee to inquire into the killings of Ahmed brothers, which will be heard by the Apex Court on April 24th. Stay tuned. The Delhi High Court today restrained all media news channels from showing or displaying material of the charge sheet in relation to the infamous Shraddha Walker murder case. Justice Rajneesh Bhatnagar issued notice on the plea moved by the Delhi police. The matter is now listed for hearing on August 3rd. If you remember last week, the trial court had also ordered TV news channel Atique to not utilize in any form any material related to the FIR. Earlier, this was limited to Aaj Now the order covers all the channels. And now coming to the news from Gujarat High Court. As you are aware, in January this year, a Supreme Court bench comprising Justices Sanjay Kishan Kaul and Abhay S. Oak, while hearing a suo motu writ petition for issuing a comprehensive policy strategy for grant of bail, had issued a set of 7 directions on the issue of under-trial prisoners. The issue being that under-trial prisoners continue to be in custody despite having been granted the benefit of bail on account of their inability to fulfill the conditions stipulated in the bail order. In furtherance to the same, the High Court has issued a circular to all the magisterial courts in the state for compliance of the directions passed by the Supreme Court. The High Court in the circular has said that bail applications must be promptly registered at the Central Filing Centre and then be forwarded to the concerned court. The High Court has also directed the concerned Principal Judicial Officer to arrange for optimal staff duty for the case information system registration of bail applications on all working days and also when urgent work is taken up at the court premises on holidays. The High Court has ensured that coordinated efforts would be made by all stakeholders to ensure timely hearing and disposal of bail applications. Thank you for watching. If you wish to know more details about the cases I mentioned here, please visit our website at www.livelaw.in. Stay ahead with quick legal updates only on LiveLaw. Do not forget to like, share, and subscribe and support us.